understand that the main reason for joining this afternoon is not to hear me, but to end this very exciting competition. So on behalf of the Faculty of Law of the University of Antwerp, a warm welcome to all of you. As Professor Mason just said, we would have loved to welcome you in Antwerp this spring. It was already promised for last year's competition, and the idea was that by now we would be back to normal. As you know from the case itself, the pandemic is not yet over, and so we continue in this digital mode. We are particularly happy and proud to host the final of the Pax Moot for a number of reasons. One is that we are really eager to support international mooting and international contacts of students, and this Pax Moot allows for that. Diversity is also an essential element of our faculty's policy, and we are happy to see that there are bachelor and master students, native English speakers and other language speakers, European and Asian students, all joining this effort. And finally, of course, we also realize that private international law can really help in accommodating diversity and in solving complex, what we now call wicked global issues and problems. So for all these reasons, we are extremely happy to have you with us this afternoon. And I would like to thank in particular all of you, of course, but also the colleagues involved from our faculty, Professors Mason, Rutten, Pertigas, and Kruger. And I wish you all a lot of success, but above all, great fun this afternoon. Good luck.
Fine. Thank you very much, Mr. van den Holen. And I think now the great moment has arrived, and we do not longer wish to keep especially the students in waiting. So I suggest that we start right away with the finals. But still, before doing so, I would like to present to you the three judges that will sit on the bench for this final, because we are very happy to have with us three very distinguished and renowned scholars in private international law, who will ensure a high quality evaluation of the students' achievements. And moreover, as is fitting, I think, for this international moot court, our panel is obviously international as well. It has links to Belgium, to Germany, to the United States, but also to the EU, to The Hague, and many other places and venues. I present to you Professor Louise Ellen Tietz. She is a professor in private international law and international procedural law at the School of Law at Roger Williams University in Rhode Island, the United States. She has actually a special connection with the Hague Conference and the Hague Conventions, and you know these are also quite pertinent for our case, because Louise Ellen has earlier served a few years as first secretary of the Hague Conference on Private International Law. Karel van de Kerkhoven is head of the Gender Equality Unit of DG Justice and Consumers at the European Commission. And although her current activities at the Commission mainly focus on gender equality, Karen has a very strong academic profile in private international law as well, through her publications and professorships earlier in Antwerp, but most recently also at Louvain-la-Neuve. And the bench of judges will be chaired by Ralph Michaels. Ralph is since 2019 director at the Max Planck Institute for Comparative and International Private Law in Hamburg, Germany. Additionally, he's a global law professor at Queen Mary in London and professor of law at the University of Hamburg. And earlier, he has for many years been a professor at the Duke Law in the United States. Thank you very much to all the judges for being with us and for contributing to this panel. We are very curious to see what will happen next and how the students will perform. I think the student teams are ready, the judges are ready, so all is set for excellent finals. Good luck to the two teams, and without further ado, I now give the floor to Professor Ralph Michaels as the chair of the judges. Please, Professor Michaels.
Thank you, Johan, very much. Welcome, everyone, to this hearing in a dispute between the citizens of Hira and Mrs. Lee, against Global Medical Inc. in front of the Court of First Instance of Antwerp. The judges have already been introduced, so we will not again do that. I also understand that the times have already been allocated for applicants and respondents, so I will not need to make time for that. And so I will ask first member of the applicant, please, to begin your pleading.
Mr. President, Your Honours, may it please this court. My name is Grace Sim, and with me is my co-counsel, Mr. Keith Toh. We appear on behalf of the claimants, the citizens of Hira, and Ms. Lee. I will be speaking for a total of 20 minutes on the first and second issue regarding the claim, and my co-counsel, Mr. Toh, would then speak for another 18 minutes regarding the third issue on the counterclaim. We will be reserving 2 minutes for rebuttal. Mr. President, Your Honours, the Brussels I regulations recast is premised on procedural efficiency and an access to justice. The present situation before us today is one where hundreds of Iran claimants have suffered from serious and wide-ranging injuries. Consequently, they have lost their jobs and require redress. The issue before the court today therefore boils down to one main question: how best may this court facilitate the access to justice? Against this backdrop, I have two submissions before the court today. First, the Belgian proceedings should not be stayed. And second, the applicable law is Belgian law. Turning to my first submission, the Belgian proceedings should not be stayed. Preliminarily, this court has jurisdiction over the dispute pursuant to Article 4 and 63 of the Brussels regulation. This is because the defendant, Global Medical, is domiciled in Belgium, and as it has its place of central administration in Belgium. This court's proceedings falls under Article 34 of the Brussels regulation, and under Article 34 of the Brussels regulation, this court may grant a stay of proceedings where, first, it is expedient to hear and determine the related actions together to avoid a risk of irreconcilable judgments. Second, it is expected that the court of a third state can give a judgment capable of recognition and enforcement. And third, a stay is necessary for the proper administration of justice. Now, this court may grant a stay where all three requirements are established by the defendant. However, we dispute that the third requirement is not met. To this end, we make one main argument that a stay would not be in the proper administration of justice. Mr. President, Your Honours, a proper administration of justice was clarified to mean, and I quote, that litigants are to better benefit from an easier access to justice and predictable rules of jurisdiction. This was held by the European Court of Justice in the 2014 joint cases of Sophia Marie Nichols Sanders and David Verhagen, and Barbara Huber and Manfred Huber. In this regard, we argue that a stay would not provide an easy access to justice for three reasons. First, not all the claimants may obtain an easier access to justice before the California courts. Second, the Californian courts would not provide a judgment within a reasonable time. And third, the Court of California has little connection to the facts and the parties. Now, these reasons should be considered by this court in totality. Turning to my first point, the claimants acknowledge that some of the Hiran participants are included in the Californian class action as stated in paragraph 1 of the clarifications. However, there remains a portion of the HIRAN claimants before the courts today that are not part of the Californian class action, particularly the HIRAN researchers. And now, crucially, they will not be able to join the Californian class action to obtain an access to justice. Now, this is because the requirement for joinder under California law is narrow and not met on the facts. Section 378 of the California Code of Civil Procedure requires that to join a class action, the claimants must have a common question of law and fact. However, this is not easily made out according to California law. As stated in the Californian case of City of San Jose and the Superior Court of California, the fact that the plaintiffs did not suffer the exact same degree of damage was sufficient to hold that there was no common question of law or fact, and consequently the claimants were unable to join the Californian class action. In our present case, the differences are even more distinct, not only because the types of damages requested both before the courts today and the Californian class action are different, but also due to the additional claim of inadequate information brought by the HIRAN researchers. As stated in paragraph 17 of the facts, the HIRAN researchers bring forth a claim of inadequate information, and this is not encompassed in the Californian class action, which is for a loss of income and the deaths of family members, as stated in paragraph 16 of the facts.
Councillor, thank you very much. Let me briefly introduce for a clarificatory question. You're educating the court here about your predictions, I understand, of how a Californian court would rule on a joinder motion. Has a joinder been attempted? Have the parties attempted to join the Californian proceedings or not?
Mr. President, on the facts, the claimants have not sought to join the Californian class action proceedings. However, what we are simply contending is that the HIRAN researchers in particular will not be able to obtain an easy access to justice before the Californian courts, and on that basis, the Californian courts would not provide an easy access to justice to all the claimants before the Belgian proceedings.
I understand that. Let me just quickly ask again, why shouldn't we ask the parties to first file that motion in California before we try to speculate on whether a Californian court would or would not allow them into the proceedings? Thank you.
Mr. President, there is a possibility. However, proceeding on the assumption that the claimants were not aware of the Californian class action, specifically the HIRAN researchers who were not aware of the Californian class action, then in that regard, we would have to continue to hear the proceedings here before Belgium to decide on whether this court should stay its proceedings or continue with the action. In any case, the Californian courts will not provide a judgment within a reasonable time. This is an important consideration provided by Recital 24 of the Brussels Regulation. As stated in Recital 24, this court should consider, and I quote, whether the court of a third state can provide a judgment within a reasonable time. Further, Article 6.1 of the European Convention of Human Rights provides for the overarching legislative intent to enshrine the right to a hearing, including for one's civil claims within a reasonable time. Now, in determining what is a reasonable time,
could I ask a question about the reasonable time? Why you have decided that the California courts would not at least provide a ruling on whether the HIRA claimants could be included in a class? If the court denied that initially, you would know very quickly that there was not the overlap.
Judge Teets, indeed, why we are suggesting that the Californian courts will not provide a judgment within a reasonable time and have not decided on the matter of whether or not the claimants in the overlap will be able to be part of the class action in California is on the basis of paragraph 16 of the facts. If I could refer, Mr. President, and your honors with me to paragraph 16 of the facts, the last sentence. Can I check your honors are with me? The Californian courts have not yet certified the class action, nor even accepted jurisdiction. Judge Teese?
Yes, I just, they haven't done that yet, but I'm not sure why you assume they will be slower than other courts, or that there is a significant time lapse that would occur.
Certainly, Judge Teets, in relation to whether there will be a significant time lapse that will occur with regard to the certification activity, the report by the Judicial Council of California indicated that there will be a mean time of 500 days before class actions are certified, and even then, 3/4 of class actions end up being discontinued. So on this basis, there is a risk that there will be a delay or a potential possibility that the claimants will not have the class action continue in California. Now, this is exacerbated by the fact that the parties to the class action still remain unknown. On the facts, as stated in paragraph 16, Willie the Whale Shark has requested to join the California class action. Now, this is in spite of his tangential environmental interests. Now, on this basis, it still remains open as to how many parties would still seek to join the Californian class action, which would present further delay for certification activity. In any case, if we look to what constitutes a reasonable time, the claimants here experience a risk to physical health. And where there's a risk to physical health, case law has demonstrated that courts must proceed expediently. In the case of X and France, the fact that a single plaintiff had suffered from immunodeficiency, a condition that was said to persist and continue to affect his day-to-day living, was sufficient for the court to hold that the courts had to proceed expediently.
But
in our case,
my understanding is you're seeking damages. So that the question of risk to physical health, you're not seeking any sort of injunctive relief. Perhaps I misunderstood the facts, but that was, are you seeking damages, so therefore the idea of risk to physical health or it continuing is not an issue, correct?
Judge Teets, we are indeed seeking damages as the claimants. However, these damages are urgent and would still depend on the fact that the risk to health continues to persist. Now, this is because these damages are required to cure the health injuries, which are permanent conditions and have rendered the claimants unable to obtain a source of income. And this was precisely held in the case of X and France, whereby the claimant was unable to continue with work on the basis that immunodeficiency was a permanent condition.
Thank you.
On the facts, this risk to health is even more pronounced since hundreds of claimants have their health at risk. As stated in paragraph 9 of the facts, the claimants have suffered from severe allergic reactions, ranging from severe heart palpitations, allergic reactions, and to more permanent consequences of kidney damage and immunodeficiency. Now, these conditions will continue to affect their day-to-day living, and without redress, these claimants will remain vulnerable. Now, seen in light of the claimants' urgent needs, and the fact that there is a risk of discontinuance or lack of certification activity before the Californian courts, it cannot be said that the Californian courts would provide a judgment within a reasonable time. This leads me to my next point on connection, that the Californian courts have little connection to the facts and the parties. Now, the point of connection is provided in recital 24 of the regulation, and this states that the court should consider the connection between the facts, the parties, and the third state, California. Now, on the facts, the only connection to California is that California was where some of the clinical trials took place, and that some of the claimants before the Californian class action are Californian researchers. Instead, Your Honours, all other factors point towards Belgium as the more proximate court to the subject matter of the dispute. Now, the proximity of the courts was identified to be a relevant consideration for these courts in the case of Owens Bank and Braco. Now, on the facts, Belgium has the most significant connection and is most proximate for the following reasons. Belgium is where Global Medical is domiciled. Belgium is where Global Medical has its place of central administration, and Belgium is also where the vaccine JAWS was developed. Given the lack of connection to California, it cannot be said that California is the more proximate court to provide an easier access to justice. Turning now to my second submission, the applicable law is Belgian law. The applicable provision is Article 4 of the Rome II regulations.
Counsel, can I briefly interrupt? Yes. Thank you for your first submission. I would like to ask, because if the court will consider whether or not to grant a stay under Article 34 of the Brussels I regulation, we will consider several elements, yes? And I understand that you have focused on one of those elements. Could you very, very briefly, in a couple of words, say why, if we were not convinced by your submission on that element, which I'm not suggesting, but just to be prepared on our side, what would you think about the other elements? Very briefly, in a couple of words. Why do you think that the stay should not be granted on these two other elements? Thank you.
Certainly, Judge van der Kove. In relation to Limb A on a risk of irreconcilable judgments, while we acknowledge that broadly speaking, there may be a common question as to Global Medical's liability. However, the specific claims before the Californian courts and the Belgian courts are different on the basis that before the Californian courts, it is a claim for loss of income as well as the death of family members, whereas before the Belgian proceedings, it's specifically related to inadequate information as well as physical injury, which has a different legal basis. In addition, the parties to the Californian action and the Belgian proceedings are different. Next, on Limb B, with regard to whether or not a judgment will be capable of enforcement and recognition, we do note that a transnational class action in our present case, especially one that relates to a US class action judgment, may face difficulties in recognition and enforcement on the basis that it relates to an opt-out mechanism, as well as the fact that the parties are indeed across many jurisdictions. And on that basis, this court in Belgium may have difficulty recognizing a class action judgment that's different in scope and in terms of its mechanism. Turning now to my second submission, the applicable law is Belgian law. The applicable provision is Article 4 of the Rome II regulations, as the present dispute includes one relating to non-contractual obligations owed by Global Medical to the claimants for the use of JAWS. Now, Article 4.1 provides for the general rule and points towards Iran law. Nevertheless, this court may apply Article 4.3, and I quote, to adapt the rigid rule of Article 4.1 to reflect the center of gravity of the situation. Now, this is stated on page 12 of the explanatory memorandum. And to this end, we make one main argument that the Article 4.3 exception applies in our present case, as the center of gravity is in Belgium and the tort is manifestly more closely connected to Belgium. Now, while the claimants acknowledge that the threshold to invoke Article 4.3 is high, this is, however, met on our facts given the specific nature of the tort, specifically one that arises closely from management decisions. Now, in such torts, it has been held that the place of management decisions is sufficient to establish the manifest high threshold. Now, this is because the center of gravity of the tort would be where the planning and decision-making activities occur. This was stated in the 2013 case of Fortress Value Recovery Fund and Blue Sky Special Opportunities Fund. Now, in the case, the tort was said to closely stem from management decisions on the basis that the fund was run and managed by managers. And in that regard, it was held that the center of gravity was London, where the fund's central decision-making and planning activities occurred. Likewise, in our present case, the tort stems from Global Medical's management, and accordingly, the center of gravity will be where Global Medical made decisions pertaining to the use of JAWS. Now, the claimant...
Let me just inquire quickly. I know you don't have a lot of time. Is it the case that which are the relevant decisions taken for you? Are they decisions taken by Global Medical, or are they decisions taken by VP Moore in HERA?
Mr. President, we do note that decisions have been taken by VP Moore in relation to the clinical trials conducted in HERA. However, this is limited to the extent that VP Moore were the ones who recruited the clinical trial participants. Nevertheless, the decision to use JAWS was one that was solely made by Global Medical. And also VP Moore was a local laboratory that was contracted ultimately by VP Moore. As such, the decision to use JAWS was made solely on the part of Global Medical. And if your honors can refer with me to paragraph 8 of the facts, and I quote, that Global Medical decided to use the synthetic adjuvant JAWS without further testing. As demonstrated by paragraph 1, as well as paragraph 2 of the clarifications, Belgium is therefore where Global Medical has made all of these management activities and decision-making, since Belgium is where Global Medical had all its offices, and Belgium was also where research and development pertaining to JAWS have occurred. Furthermore, Your Honours, all other circumstances of this case points towards Belgium as the center of gravity of the tort, since the synthetic adjuvant JAWS was manufactured and also distributed in Belgium. If Your Honours can refer with me to paragraph 2 of the clarifications. Can I check Your Honours are with me? Belgium is where Global Medical had 2 of its pharmaceutical plants, which played a role in the supply of the synthetic adjuvant JAWS vaccine. Belgium is also where Global Medical had 2 international distribution facilities, which contributed to the distribution of vaccines to HERA. And Belgium is also where Global Medical had a clinical pharmacology unit where clinical trials took place. As such, there's a clear preponderance of factors that points towards Belgium as the center of gravity of the tort. Accordingly, Article 4.3 exception applies, and the applicable law by this court remains as Belgian law. In sum, this court should not stay the Belgian proceedings, as it would not be in the proper administration of justice. And second, the applicable law is Belgian law. I note that my time is up.
Yes.
Thank you, Carl.
Unless I may be of any further assistance to this court.
Thank you very much, Counsel. We will move to respondent, please.
Thank you. Mr. President, honorable judges, and if it please the court,
My name is Max Bohn, and I'm here with my learned colleague, Julian Tillmann. It is our pleasure to represent Global Medical Incorporated before this court today. The time allocation for our pleadings has already been provided through the Zoom chat. This case today is not about the question of access to justice nor substantive justice, but is about abusively brought proceedings about alleged side effects as well as utterly reprehensible patent infringements. With this being neither a question of choosing the law which is most suitable for a potential weaker party, nor anything related to that, but being a matter of equal jurisdiction and a question of the law fitting best to this case. Following this, our submissions are as follows. Firstly, I'll argue that the court must stay the proceeding according to either Article 33 or Article 34 plus a 1 recast. Secondly, we will show that all the claims are governed by Hyrule law according to the Rome regulations. And lastly, my learned colleague will argue that a judgment on the counterclaim would be enforceable in Hyrule regarding the Hague Convention. If it pleases the court, I'd like to turn over to my first submission. We submit that all the necessaries for a stay of the proceeding, even to the narrower scope of Article 33, are met. And even if the court does not follow our submission that the cases must be at least deemed to be so closely related to one another that a stay is necessary in order to gain the proper administration of justice. This is in order to reach the purpose of the whole Brussels 1 recast, which is to avoid irreconcilable judgments and not, as the opposing counsel stated, to find a forum which is more convenient for one party. Regarding Article 33, my structure will be as follows. As the opposing counsels agreed on, general provision is given by Article 4, and both of them are in between the same course of actions. I'd like to go further on with the necessary that both must be in between the same parties, and concluding, talking about the discretion of the court. As it regards, like the opposing counsel mentioned, that both of the proceedings are not in between the parties, we have to strongly disagree. We have to look on the extent the parties on the proceedings before the courts are overlapping. And isn't it beyond all doubt that Ms. Lee, as well as the hiring volunteers, are represented in both of the proceedings, this one today and the one in California? And as the opposing counsels don't defend the volunteers, which have brought claims to the Belgian court as well, we do not have to consider whether a stay regarding those researchers, talking about researchers, must be deemed necessary or not, but at least it must be deemed necessary regarding Ms. Lee and the hiring volunteers, as they are overlapping with the Californian parties.
Counsel, just to interrupt, and maybe I am not sure of the facts, are you alleging that all volunteers before our court here today are also parties or in the Californian proceedings, in addition to Ms. Lee?
At least there is an overlapping factor. So this overlapping factor must be seen as the 22nd recital of the Brussels 1 regulation states to be enough that it is or must be deemed necessary to stay this proceeding in order to avoid irreconcilable judgments and conflicting contradictory decisions. But even if the court found both of the...
I'm sorry, did you say Article 22? Sorry, did you say paragraph 22 with the recitals?
At the 22nd recital.
Which is dealing with exclusive choice of court agreements?
You said 26, is that right? Or 22?
I'm sorry, I thought he said 22, not 23 or 24. That was all.
Well, we are considering we are submitting the consideration of those recitals from 21 to 24 as a whole in order of the discretion of the court, which is given through the application of Article 33 or Article 34. So even though they might be not applicable directly to those clauses, because they are aiming towards the lis pendens in this regulation, they must be considered during the exercising of the discretion of this court today. And as both the lis pendens as well as Article 33 and 34 tend towards the same avoiding of those irreconcilable judgments, they must at least be considered.
I'm sorry, I just I was confused because I would think you would rely instead on recitals 23 and 24, not specifically 22. So that's why I wanted to clarify. Obviously, they deal with Articles 33 and 34. So thank you.
And
Counsel, let me just quickly ask for my clarification. I know you will get to Article 34 later, and maybe then things will be resolved. But are you arguing now that an overlap between the parties is enough to fulfill the requirement of same parties in Article 33?
we are arguing, as the CGEU stated in many of his cases, especially in his case Tatri and Wolf versus Cox, that an overlapping of the parties must be deemed to be enough to stay the proceedings relating to those overlapping parties. So as both Ms. Lee as well as the hiring volunteers are represented in both of the proceedings, a stay must be deemed necessary according to those mentioned parties.
I just had a question, Counsel. Tartra is an interpretation of Article 29, is it not? It doesn't deal with third parties. Are you suggesting that we should apply it the same way?
As I mentioned previously, those decisions made up on the lis pendens of the regulation, the part about the lis pendens, must be at least considered during the exercising of the discretion of Article 33 and 34, which at the heart of the basis tends towards the same purpose of the whole regulation, to avoid those conflicting decisions. Thus, they must be at least considered.
Let me nonetheless, and then I'll let you go on, Counsel. As I read Article 33, part of it talks about the requirements, and that's the same cause of action, same parties. And part of it grants discretion, the may part. But the discretion would come subsequently to fulfilling the requirements, right? In other words, if the requirements were not fulfilled, we would not have any discretion to stay.
We do agree with you, honorable bench, but we submit that both of the proceedings are at the same course of action, because at the heart of the proceedings, both of them tend towards the same alleged liability of Global Medical due to the claimed use of the adjuvant jaws. So looking at the heart of the basis, both of the proceedings are in the same course of action. And as I mentioned earlier, both of them are at least overlapping, which satisfies the requirements of Article 33, and that it must be in between the same parties. So, but to go on, even if the court found this requirements not to be fulfilled, we at least urge the court to stay the proceeding according to Article 34 plus a 1 recast, as both of the proceedings must be deemed to be so closely related to one another that not staying this proceeding today would not only lead to irreconcilable judgments, but also bear a huge risk of conflicting contradictory rulings. And regarding the discretion of the court, we'd like to refer to the mentioned Article 21 to 21 to 24, where it is written or stated that the court shall have a flexible mechanism and look at all the circumstances of the case before it. So regarding all the circumstances and this mentioned flexible mechanism, it is not only for the purpose of avoiding irreconcilable judgments, but moreover for procedural efficiency to stay these proceedings, as both the Californian one and this today are at the same course of action, and the Californian one is, as the opposing counsel agreed on, in its extent bigger. Therefore, awaiting this ruling leads to a simplification of this process we are hearing here today. And we have to submit also that staying the proceeding does not equal dismissing it. So we are just awaiting this other proceeding in order to simplify ruling on this case.
Counsel, can I briefly ask you a question? Because I find it very interesting that you refer us to the guidance in the regulation regarding the lis pendens rules. But what do you think? Should this court take into account also the element that perhaps the guidance for us in applying the lis pendens rules in a European context, where we have a certain degree of integration among member states and judicial systems, wouldn't that justify perhaps a more flexible interpretation of Article 29 compared to Articles 33 and 34 in regard to third states? Why do you think that we should be applying the same principles, or shouldn't we take into account a different context?
We agree with you totally, Honorable Judge. So that's why the recitals only mention the part of the lis pendens of this regulation, but it must, for the discretion of the court, be considered that both the lis pendens, which is in between member states, as well as the regulations regarding third states, tend towards the same goal, which is to avoid those irreconcilable judgments. So why not considering it and taking them and at least looking at them while exercising the discretion? That is our submission regarding this point. So concluding my first submission, we urge the court to stay the proceeding according to either Article 33 or at least Article 34. And as far as it considers the court, if this Californian judgment would be capable of recognition and enforcement, would just refer to the tenet established by a Belgian court in Lernoux and Torspy that judgments from third states are still subject to the substantive law of this country here, and that they are therefore, in the first instance, must be considered as capable of enforcement and recognition.
Would it be a concern in that regard that the Californian action is likely to be a class action?
It would not. The Lernoux and Torspy especially dealt with class action proceedings, that they are still subjects to substantive law, even if the Belgian law does not know something similar to or even if the Belgian law does not know something similar to class action lawsuit. So that's why they must be considered to be capable of enforcement and recognition. So do you have a question?
I had actually a very small follow-up question. There may be other reasons why the judgment from the California court may encounter difficulties here. What would you think, counsel, if the California court were to impose punitive damages, which is, I think, a typical feature of many states, including California State Civil Procedural Court?
I'd like to refer again to the tenet established in Lernoux and Torspy, where it is also stated by the Belgian court that would be no problem to just limit the damages which are awarded in the Californian proceeding to the extent under which they are capable of enforcement under the substantive law of Belgium. So they can't just limit it to the possible extent, but have to consider it as capable of enforcement and recognition in the first place.
What about, excuse me, counsel, you've heard the arguments that the California case is not particularly connected to California other than the few volunteers. Would the judgment have enforceability issues in terms of jurisdiction? In other words, would a Belgian court find that there was in fact adequate jurisdiction?
As the performance of the vaccine took not only place in Haifa, but also in the USA, and moreover, Global Medical has its statutory seat in the USA, and
that's in Delaware, not California.
Yeah, was just referring to the USA as a whole, and thank you for the clarification. And the hiring volunteers just joined that class action lawsuit, so they were willingly going into that extent of the proceeding. There must not be seen hierarchy between the jurisdiction of the Californian court regarding claimed liability over the proceedings before a Belgian court, nor anything else. I'd like, if it please the court, I'd like to turn over to my second and concluding submission, that Highland law must be applied to the non-contractual claims. My structure regarding this will be as follows. Firstly, I'll talk about why we must apply the lex locus standi to Article 4, paragraph 1, and after that, why there's no need for the application of an escape clause. Firstly, the general provision of Article 4, paragraph 1 leads to the application of the law where the direct damage occurred, as all of the relevant steps to these proceedings, as well as all of the claimed side effects and torts occurred solely in Haifa. It must be seen that this is the place where the claimed direct damages occurred. Hence, through the application of the lex locus standi, which is the general provision, said again, must Haifa law be applied. And as this is a connection to Haifa, which is in its extent wholly seen so strong that there must be an even stronger connection to another country in order to apply an escape clause to Article 4, paragraph 3, would like to refer to the recitals 16 and 18 of the Rome II regulation, where it is stated that escape clauses must only be used in exceptional cases, and doing so anyways would lead to unpredictability and rather contemplation. So we submit there is no exceptional case given here, as everything that is relevant to which law should be applicable clearly leads to the application of Haifa law and Haifa law alone. So opposing to what the opposing counsels argues, there must not be seen a closer connection to Haifa.
Counsel, you heard opposing counsel argue that there were significant connections to Belgium, and you are aware of recital 14, which suggests a need for flexibility in appropriate cases. Could I ask you to respond to applicants' suggestion of significant management decisions haven't been taken in Belgium?
Well, as we agreed that there might have been management decisions regarding before starting the performing of the vaccinations, those were not the things that lead to the claimed torts occurring. What what caused the torts to occur at all was solely the performance of the Paimo and the Paimo alone. Hence, even if there were management decisions taken by Global Medical in Belgium or Delaware at all, there must not be seen a closer connection towards those countries, as they are not related to the occurring of the torts. So this flexible mechanism must again provide the application of Highland law, as this is the law which is predictable and foreseeable, and hence also a protection for the weaker party.
I understand that. Let me just try to get some more clarification. Applicant argued that in regards to everything that mattered, VP Mo had no real choice but to act in the way that they did due to the management decisions taken in Belgium. So I understand your argument to be the formal one, to say the actual decision was taken in HERA. Applicant was making a broader argument to say ultimately responsibility here should lie with Global Medical for its decisions, and for that reason relations should be there. Are you suggesting that that we should rely on the formal question rather than substantive assessment, or are you also suggesting that the substantive assessment that applicant suggests is also not accurate?
Even if we want to talk about a substantive application or viewing of this escape clause, we have to submit that Global Medical solely choose the Paimo because of their long-standing reputation and their placement on site of the spread of the virus. So it was them themselves who contracted with the volunteers and performed the whole testing in regards to how such testings may be performed in the extent of the Highland government or Highland law at all. So even if there might have been Global Medicals advising to performing of the testing before the start, they themselves performed the whole testing, and there was no supervision or administration by Global Medical at all. And that's why even through the view of a substantive view, we have to submit that every relevant decision regarding the cause of the claimed torts or side effects only occurred due to the performance of the Paimo, which therefore leads also to the application of Highland law. And if the court does not have any further questions, I'd like to conclude my submission.
I'll just throw in one more question. Just would you argue differently, or should we view this case differently if VP Mo was a wholly owned subsidiary of Global Medical?
Well, if the Paimo was to be ascribed to Global Medical at all, which is not the fact what we are.
I know that. I'm just asking a hypothetical.
Then we could argue about contractual claims, as that could be the case, but even then we don't think.
No, my question is on tort. My question is on Rome 2 regulation. Would it change your assessment if VP Mo was a wholly owned subsidiary, meaning they would be subject to directions from the Belgian parent?
Even then,
we look at Article 4, Rome 2 differently in that situation.
Even then, if we might ascribe the Paimo to Global Medical, it was solely performed by, as you call it, a subsidiary of Global Medical in HIRA solely, and hence, as the Rome 2 regulation looks at which law is the most suitable for this case and is most closely connected. Even then, even if there was a relationship between the Paimo and Global Medical, it must clearly be deemed for Highland law to be the most closely connected to this case, and therefore be the one applicable.
Thank you.
So, in concluding my submission, we urge the court to stay the proceedings either to Article 33 or deem both of the proceedings to be so closely related to one another that a stay is necessary regarding Article 34 plus a 1 recast and to apply higher law to the non-contractual claims. With this, honorable bench, I'd like to thank you for your attention and pass words to my learned colleague.
Thank you very much, Counsel, for your argument, and we will hear from Respondent 2 now, please.
Thank you, Mr. President. Honorable judges, I will now address the enforceability of an ensuing judgment on the counterclaim in the state of Hira. Arguing in two parts, I will show that first, the 2019 Hague Judgments Convention, which in the following I will simply call the convention, is applicable, and that second, its requirements when it comes to the counterclaim at hand are met. Coming to the first point. Article 1 of the convention sets out its scope. Following this provision, the convention extends to judgments in civil or commercial matters between contracting states. First, the counterclaim is of civil nature, and second, both Belgium and Hira are contracting states to the convention. While this means that the convention generally is applicable, exceptions to its applicability can be found in Article 2, paragraph 1. According to Article 2, paragraph 1, litera M of the convention, matters of intellectual property are excluded from its scope. The counterclaim is aiming at preventing Ms. Lee from producing and selling the vaccine in the state of Hira, where the formula is protected by a patent. While this admittedly touches on intellectual property matters, this does not mean that the convention is not applicable, since, according to Article 2, paragraph 2 of the convention, a judgment is not excluded from the scope of the convention, where a matter to which this convention does not apply arose merely as a preliminary question in the proceedings in which the judgment was given, and not as an object of the proceedings. The application of the convention is therefore determined by the object of the proceedings. Emphasis should be put on the usage of the term proceedings. The convention therefore does not isolate single issues, but instead applies the overall picture of what it calls the proceedings. The remaining question is what the term proceedings precisely includes. In interpreting the convention, the explanatory report by Gassi-Martin and Sommier can provide guidance. While it is not legally binding, it is still a strong basis for interpretation, since according to Article 20 of the convention, in interpreting it, regards shall be had to its international character, as well as to the need to promote uniformity in its application. Following this explanatory report, the convention includes both the original as well as the counterclaim within the term proceedings. If the object of those proceedings is therefore not a matter of intellectual property, then the exclusionary provision of Article 2, paragraph 1, litera M of the convention is overruled by Article 2, paragraph 2. When it comes to the, yes, a question.
My head is spinning a little.
Excuse me.
It seems to me that you now argued that IP is outside of the scope, but because of Article 2.2, it has to be read in, whereby it certainly is within the scope. Let me first ask, in the system of the Hague Convention itself, we have a specific provision for counterclaims, right? Which is Article 5, that is letter L, as you know. Could you tell me why you're not relying on that and instead on Article 2, paragraph 2?
So right now I'm presenting my first submission, which is solely on the applicability of the convention. And when it comes to the specific requirements of the convention for enforcing judgments, then I will go into the details concerning Article 5, paragraph 1, litera L number 1.
Good.
Thank you. So, as was just established, if the object of the proceedings is not a matter of intellectual property, then a judgment can be enforced under Article 2, paragraph 2. When it comes to the term object, the explanatory report states that it is intended to mean the matter with which the proceedings are directly concerned and which is mainly determined by the plaintiff's claim. Not only does this provide a definition for the term object, it also gives us a tool for how to assess it. In assessing, special emphasis is put on the original claim. In our case, the original claim seeks financial compensation for vaccination damages that allegedly occurred in the state of Hira. This is a matter that falls within the scope of the convention. The question is therefore if the introduction of the counterclaim warrants to divert from this original object. The counterclaim, however, did not introduce complex questions to these proceedings. The existence of a patent in the state of Hira is not at debate. Furthermore, Ms. Lee intends to produce and sell the vaccine in Hira, which is in violation of the granted protection. Therefore, judging on this matter should not produce any significant difficulties for this court. The original claim, however, features a much more disputed claim. It relies on uncertain circumstances and relationships between the parties that will all need to be untangled by this very court before reaching a decision. The object of the proceedings, and to put it in the words of the explanatory report once again, the matter with which the proceedings are directly concerned is still the original claim as introduced by Ms. Lee, her fellow researchers, and Hiran volunteers to the testing program. The matter of intellectual property is therefore merely a preliminary question under the convention, and the convention applies following Article 2, paragraph 2. If there are no questions on this subject, I would like to move on to my second submission.
No, unfortunately, I need to ask a question. The words in Article 2 are preliminary, which seems to suggest that they should be prior to the connection. You argued that they are relatively simple, and so they should just be dealt with at the same time. That seems to be something different, or are you suggesting that they're the same, or am I missing the course of the argument here?
So it is our first and main submission that for determining whether a question is of preliminary nature or if it is at the heart of the claim, the convention applies the overall picture of the proceedings. And within that scope of the proceedings, the matter of intellectual property can only be classified as a preliminary question. Now, furthermore, the matter of intellectual property, even if we only look at the specific counterclaim, is the existence and the extension of the granted protection by the patent in Hira, while the court injunction will be an injunction that will prevent Ms. Lee from producing and selling the vaccine, which will not directly rule on the preliminary question, but only be relying on the results to this answer. So if this answers your question, I would now like to move on to my second submission, where I will answer your very first question and show that first, the filters of Article 5, paragraph 1, litera L, number 1 of the convention are fulfilled, and that second, the further requirements that are set out in the convention when it comes to enforcing judgments on preliminary questions are also fulfilled. First, Article 5, paragraph 1, litera L, number 1 of the convention states that a judgment is eligible for recognition and enforcement if the judgment ruled on a counterclaim to the extent that it was in favor of the counterclaimant, provided that the counterclaim arose out of the same transaction or occurrence as the claim. Once again, according to the explanatory report, the wording transaction is meant to have a wide scope referring to the parties' relationship. Same occurrence emphasizes that the facts of the two claims do not need to be identical, but instead arise out of a broader, still related set of circumstances. In applying the provision, its underlying intention and function should also be considered. In our case, the provision follows the principle that under the convention, a judgment against a party that consented to the court's jurisdiction can be enforced without further requirements. The explanatory report calls these filters established by consent. And this consent can be granted either expressly, as is the situation described in Article 5, paragraph 1, litera E, and it can also be implied by having brought the corresponding claim, as is the situation described in Article 5, paragraph 1, litera C, and the relevant special provision on counterclaims in this case, Article 5, paragraph 1, litera L, number 2 of the Convention. Now, in the case at hand, neither did Ms. Lee expressly consent to the court's jurisdiction on the counterclaim, nor is she the one that brought the corresponding claim. Nonetheless, it was still her and her decision to initiate the overall proceedings. Without that decision, the counterclaim could not exist as such. The question is therefore if Ms. Lee's subjection to this court's jurisdiction by initiating the overall proceedings with her original claim can be extended to the counterclaim. If the matters are closely enough connected that Ms. Lee could have foreseen the counterclaim being brought against her when she initiated the overall proceedings, then her consent can and must be extended to the counterclaim. Therefore, the filter of the same transaction or occurrence as established in Article 5, paragraph 1, litera L, number 1 of the Convention addresses the question of foreseeability of the counterclaim for the original claimant. In our case, both claims are related to Global Medical's involvement in the state of Hira, and on a broader scale are related to the developed vaccine. There are two connecting factors which are of special importance for both of these claims. First, the decision to use the adjuvant JAWS is not only, as already mentioned by the opposing counsel, at the heart of the claim for damages, but is also what led to Ms. Lee distancing herself from our client, an event that later on incited her to steal Global Medical's intellectual property. The second connecting factor is the involvement of the laboratory Vipimo. It conducted the testing in the state of Hira, therefore being of importance for the original claim. Furthermore, Ms. Lee was only able to steal the formula since, by virtue of her position as former head of the Vipimo laboratory, she already was entrusted with part of it. Lastly, since Ms. Lee did not suffer any physical harm herself, her involvement in the original as well as the counterclaim only stems from the position that she held at Vipimo. All of this shows that there is a close connection between the two claims. And now let me answer the question that was raised by myself, if the counterclaim was also foreseeable for Ms. Lee. And the answer to this question is yes. In August of 2020, Ms. Lee was fired as the head of the Vipimo laboratory. Even though our client was not involved in the decision to fire her, she put the blame on Global Medical and started a personal revenge campaign against our client. By spreading false information about the testing program in the state of Hira, she tried to swing public opinion on our client. Furthermore, she decided that stealing the formula would not only cause further damage to Global Medical's reputation, but also cause significant financial harm. Lastly, she resorted to initiating lawsuits in the states of California and Belgium. And by doing so, Ms. Lee must have expected that Global Medical would not only react by defending itself against those claims, but also try to protect its formula against misuse, especially since by releasing a statement in the past that Global Medical intended to keep the vaccine formula secret, it already made it clear that it would not tolerate any unauthorized usage of the formula. Therefore, the counterclaim was foreseeable for Ms. Lee at the time where she initiated the overall proceedings. Her consent to the court's jurisdiction can be extended, meaning that the filter of the same transaction or occurrence as required in Article 5, paragraph 1, litera L, number 1 of the convention is met. If there are no questions on this subject, I would like to move on to the second point of my second submission, which at the same time will be my final one.
I would just like to ask two things for my understanding. You argue foreseeability. Are you arguing foreseeability in order to determine whether Ms. Lee and the other plaintiffs effectively consented to jurisdiction over the counterclaim? Or are you arguing this as an element within 5L in order to determine the same occurrence? In other words, are you resting this on 5.1L exclusively, or also on the other bases of consent?
Yes, exactly. Now, it is our submission that the provision of Article 5, paragraph 1, litera L, number 1, follows this specific principle of recognizing and enforcing a judgment against a party that consented. And therefore, we are applying this underlying intention to the provision at hand. This means that it is our submission that we address the question of foreseeability within the provision of Article 5, paragraph 1, litera L, number 1.
Thank you. Just a second question, as you are undoubtedly aware, the English version and the French version differ slightly because same occurrence is même fait, same facts in French. Does this difference play a role for us? Do we have to consider that, or are you suggesting that under either of the terms, the requirement is met?
Now, it is stated in the explanatory report that the formulation of the same occurrence is specifically meant to represent the French version of same facts, and therefore it is our submission that these two versions can be compared in the present case, yes.
I understand that. The question is just, does it mean that we only have to see same facts, or do we have to, in other words, because those are different terms, which of them is the actual ultimate meaning?
According to the Vienna Convention, if there are multiple versions on different languages, each language should be considered, and it should not be only and purely based on the English version. However, it is our submissions that since the provisions are very comparative, if not identical, that it would not make any difference.
Thank you.
Thank you very much. I would now like to present my very last. Yes.
Sorry, could I ask? I'm not sure if my colleague would rather ask a question. Why don't I let you go first, and then I'll.
Okay, as you wish, Louisa. Well, that's what would you think, counsel? If I were to see the counterclaim aiming at really preventing an infringement of the patent from happening, how would you say then still that the exclusion which is in the Hague Convention would not apply? And the second question is also, what if this is the case, if it is preventing the a patent infringement from happening, then isn't this like a provisional measure that would be excluded under the convention as well? I mean, these are two elements that I think this court would need to consider also in the case, if you could briefly elaborate on them.
Thank you very much. Now, I would like to address your second question first, since it is my opinion that it is the shortest answer. According to Article 3, paragraph 1, litera B, a judgment is not an interim measure of protection. However, in our case, our client seeks a final verdict on the matter, and therefore it is a judgment in the sense of the Hague Convention. And to address your first question, it is indisputable that the convention connects the question of preliminary questions to the term proceedings. It is stated within the convention as well as the explanatory report. And it is also stated that the proceedings includes both the original as well as the counterclaim. And to add some further argument to this point, the CGU in the Danvan production case also held that a counterclaim is a separate claim made in the context of the same proceedings. So this understanding is also in line with the understanding of the CGU on that matter. Now, to quickly sum up my submissions, I would like to point out that Article 8, paragraph 3 of the convention allows, paragraph 2 of the convention allows a court in HIRA to refuse the enforcement. However, the explanatory report states that this exception should only be used when the hiring court would judge on the preliminary question in a different way. And since there is no ambiguity to the preliminary question at hand, hiring courts would also conclude that Ms. Lee's behavior is in violation of the granted patent protection, and an ensuing judgment would therefore be enforceable under the 2019 Hague Judgments Convention. And if there are no further questions, this concludes my submissions.
Thank you very much, Counsel. Highly appreciated. We will move to applicant 2 for your response.
Mr. President, Your Honors, may it please this court. My name is Keith Do, and I act for the claimants, the citizens of HIRA and Ms. Lee. I will be addressing this court for 18 minutes on the third issue, that is, the enforceability of the ensuing Belgian counterclaim judgment in HIRA. As earlier mentioned by my co-counsel, the HIRAN claimants have suffered greatly as a result of the careless clinical trials. They come before this court today seeking redress for the wrongs that they've suffered, and justice must be served by ensuring that they obtain a just outcome. The present counterclaim pertains to a situation where, after conducting failed clinical trials on the HIRAN participants, GM is now seeking to deny them of access to the resulting vaccine simply to protect its commercial interests. And we say that this counterclaim is not enforceable in HIRA. And to this end, I will make 3 arguments. First, that the counterclaim is excluded from the scope of the 2019 Hague Judgments Convention. Second, that even if it were not so excluded, it would still be unenforceable as it does not fall under any base of recognition. And third, in any event, Your Honors, enforcement would be manifestly against HIRA's public policy. Turning to my first argument, the counterclaim brought by GM is excluded from the scope of the 2019 convention. This is because it pertains to IP matters which are excluded by Article 21M. We do acknowledge that the defendants have sought to convince this court that the IP matters only pertain to a preliminary question. And we note that Mr. President earlier had concerns as to the applicability of Article 2.2. In this regard, we would say that Article 2.2 does not apply on the facts. That article would only apply where the excluded matter was only involved as a preliminary question, and in particular, where it arises by way of defense. And this is stated at paragraph 73 of the explanatory report to the 2019 convention. However, the main object for the counterclaim here is for an injunction to protect GM's patent rights over the vaccine formula. The very basis of the counterclaim brought by GM themselves therefore already concerns IP rights. Furthermore, Your Honors, in considering their application, this court would have to determine if Ms. Lee's actions infringed on GM's patent rights at all, and this would necessarily involve questions of substantive IP law. Therefore, it cannot be said that the IP matters pertain only to a preliminary question. Now, even if, Your Honors, if we take the defendant's case at its highest, and we say that the defendant may bring the the injunction on other non-IP grounds, we would say that it still nevertheless falls under the IP exclusion. If the defendant did indeed seek the injunction on non-IP grounds, the question before this court today can then be boiled down to simply this. Would the IP exception be triggered where the cause of action pleaded was non-IP, but where the remedy sought was for an injunction over subject matter pertaining to IP rights? We argue that this question can be answered in the affirmative, especially if one considers the rationale behind Article 21M. And indeed, this was the approach taken by the Court of Justice of the European Union in the case of Leo Kuhn and Hellenic Republic in interpreting and determining the scope of a particular provision. Here, the main reasons for excluding IP from the scope of the 2019 convention are its largely territorial nature, as well as the significant differences in domestic law in this regard. And this is stated in info document number 3 of May 2019. It is clear, Your Honours, that considerable respect is afforded to the courts of contracting states in this regard, and that they have the right to rule on their own IP matters. This right should not be subject to interference from foreign judgments. So although the defendants may seek to rely on a different legal basis for bringing the injunction, this would nevertheless interfere with the Huron Court's right to rule on its own IP matters. Now, Judge Van der Kover earlier queried the defendant on whether the present dispute pertained to an IP enforcement matter. And we say that yes, it does pertain to an IP matter because the essence of the counterclaim pertains to the patented vaccine formula, which the Huron courts have the right and the interest to rule on. This can be seen from both the facts as well as the clarifications at questions 9, 14, and 38. Crucially, Your Honours, question 9 of the clarification acknowledges that the essence of the counterclaim pertains to the enforcement of the vaccine patent. It is then clear that the counterclaim involves the defendants asserting their patent rights in seeking an injunction from this court. Thus, regardless of what the basis of the injunction is, it would have the practical effect of enforcement and protection of GM's IP rights in HERA by restricting Ms. Lee's ability to produce and sell the vaccines in HERA. This would thereby interfere with the Huron courts.
Go ahead.
This would thereby interfere with the Huron court's right to rule on whether Ms. Lee had infringed on GM's patent rights at all. Thus, Your Honour, enforcement of the counterclaim would depart from the rationale of Article 21M, which is to accord respect to the contracting states to rule on their own IP matters.
Counsel, thank you very much. Just a quick question on that. Of course, respondents did not argue broadly that a claim like this one should be admitted for recognition, but that it should be admitted in the case that it is a closely connected and foreseeable counterclaim. And indeed, the contracting parties did not only aim at restricting IP on the one hand, they also aimed at judicial expediency and therefore resolving whole matters in their entirety and leading to recognizable judgments. So which of those should prevail here? Should it be the reading, the broad reading of IP out of the convention altogether? Or should we take opposing sides' suggestion that this is closely related and relatively easy to adjudicate, and for that reason should be included in the recognizable judgment?
Mr. President, in response, we would say that the broad reading of IP should be preferred, given that it is mentioned in the explanatory report that the IP exclusion here is used in a broad sense. And we do acknowledge that the defendants have sought to rely on the foreseeability test to argue that the counterclaim and the claim arose out of the same transaction and occurrence. However, in response, we would say that they should still be precluded from relying on Article 5, 1L, Roman numeral 1 as a base for recognition. Now, Mr. President had earlier queried the defendant on the applicability of the foreseeability test. And we note that in this regard, the defendants have not provided any authority for relying on the foreseeability test in the context of Article 5, 1L, Roman numeral 1. Instead, we do note that the Supreme Court of the US had declared this particular same transaction and occurrence test to be one of a highly flexible application in the case of Moore and New York Cotton Edge. Therefore, Your Honors, we would agree with the defendants that in applying the same transaction test, it would be important to bear in mind the rationale and the policies underlying that provision. Under Article 5, 1L, Roman numeral 1, the same transaction or occurrence requirement serves to ensure fairness to the original claimant, that insofar as he submitted to the jurisdiction of the court in bringing the claim, it would also be legitimate for the court to rule on the counterclaim. And this is stated at paragraph 210 of the explanatory report. However, in light of this policy, we would depart from the defendant's foreseeability test and instead argue that the more relevant consideration should be whether or not there was a logical chain of causation between the events giving rise to liability in the claim and the counterclaim. Such an approach would have the benefit of ensuring that the two actions relate to the same litigable event, such that a claimant can be legitimately said to have submitted to the court's jurisdiction over the counterclaim in bringing the claim. Indeed, Your Honors, this was the position taken by the US Supreme Court in the earlier cited case of Moore and New York Cotton Edge, where the court opined that transaction did not depend so much on the immediateness of the connection between the events, but rather upon their logical relationship. Here, we say that there is no chain of causation between the claim and the counterclaim.
Can we use US case law in order to interpret the convention?
Certainly, Mr. President, we note that that case is not on all fours with the present convention. However, to the best of my knowledge, there are no cases directly interpreting this particular convention, and the US statute uses the exact same wording in a similar context of civil procedure, being whether a counterclaim can be brought. And furthermore, Mr. President, we note that the explanatory report at paragraph 208 actually refers to a US provision which suggests that the tests are similar. Turning back, we say that there is no such logical chain of causation here because in the claim, the relevant event was Miss Lee's, or rather GM's, failure to give adequate information, whereas for the counterclaim, it was Miss Lee's plans to produce the vaccine. These events do not share any logical chain of causation in that it cannot be said that Miss Lee's actions or plans would not have happened but for GM's failure to disclose information. Instead, it was simply an independent decision made by GM or Miss Lee. Accordingly, the claim and counterclaim do not arise out of the same transaction or occurrence, and the requirement under Article 5, 1L, Roman numeral 1 is not met. Accordingly, the counterclaim is unenforceable in HERA. On the third point, Your Honors, Judge Teets, did you have a query?
I'm going to wait and let you go ahead. I have a question on the main judgment at some point.
Much obliged. Now, on the final point, we do not dispute that Article 8 does not apply on the present facts. Instead, we argue that it would be manifestly against HERA's public policy to enforce the counterclaim pursuant to Article 7(1)(c). We say that this manifest incompatibility with HERA's public policy can be established on two alternative grounds. First, that enforcement of the counterclaim would manifestly violate HERA's public health. Second, that in any case, there are serious ethical and moral reasons for refusing enforcement of the counterclaim. On the first point, enforcement of the counterclaim would manifestly violate HERA's public health. This is because HERA requires urgent access to the vaccine, and the injunction would effectively deny HERA of any such access. Now, the defendants may point to certain alternatives that HERA may have to obtain access to the vaccine. However, we would contend that all such alternatives are unviable on the present facts. This is because high-income countries have obtained a large amount of the available vaccines. According to a UNICEF COVID-19 vaccine market dashboard, 86% of all vaccines administered globally have been in high and middle income countries. Now, GM is certainly no exception to this phenomenon, having acknowledged themselves that they were unable to meet HERA's demand due to pre-orders from the US and the EU. And this is stated at paragraph 13 of the facts. Furthermore, even with the COVAX initiative, a recent UN report had, in no uncertain terms, stated that the only effective way of defeating the pandemic is by allowing poorer countries to produce the vaccines on their own. The injunction is completely antithetical to this position. Finally, we do acknowledge that GM had stated that they would be able to deliver HERA's order 1 year later. However, in response, we would say that this delay in delivery would have severe implications on HERA's public health, given that the situation in HERA is dire. Now, even before the clinical trials, there were high levels of infection in the country as social distancing was difficult. And this is stated at paragraph 7 of the facts. This has since been further compounded by the failed vaccine testing conducted by GM, which led to morbidity and increased contaminations. And this is stated at paragraph 9 of the facts. We say that these exceptional circumstances would further warrant the need for Ms. Lee to produce the vaccines locally in order to meet HERA's demand. Your Honors,
So let me just ask about the standard of public policy, which of course under the Hague Convention, as in other instruments, is supposed to be read narrowly. You argue with considerable strength the very considerable interests that HERA would have in allowing this. Of course, on the other side, you know the arguments for incentivizing the producers of, or the developers of vaccines to rely on strong IP rights. And indeed, I cannot recall whether HERA is in the list of members of the TRIPS agreement, for example, but my recollection of HERA's law is that IP rights, of course, also play a considerable role. Is it therefore the case that HERA is free to invoke its defense here, or could they be bound by either international law protections of IP rights or overarching incentives to protect the developers of vaccines? After all, we're a court in the first world, as you just suggested. Cut that from the record.
Mr. President, I do note that you have two concerns relating first to the threshold required in Article 7, as well as the need for incentivization. And I propose to address your concerns in turn. Now, first, on the threshold point, we do acknowledge that the manifest threshold is a high one, And indeed, the relevant test is that the violation should be shocking to the judicial conscience of the court. And this is stated at paragraph 28 of preliminary document number 5. However, we would still maintain that this test is met on the facts. So in response to the point on incentivization, we say that this concern can be addressed on 2 levels, Mr. President. First, that the concerns or considerations of incentivization should not be determinative here, given that the circumstances in HERA are dire. Indeed, Mr. President, some pharmaceutical companies themselves have recognized such importance, and that doing so would be in line with their corporate social responsibility, thereby benefiting their public image. For example, Moderna, who is another vaccine manufacturer, has pledged not to enforce their IP or patent rights during the pandemic to increase the quantity of available vaccines. Thus, the effect of incentivization may be overstated. Second, and in any event, Your Honor, we would say that such an argument would not have an overriding or determinative effect, as it does not directly address the public health and moral or ethical concerns, such that the public policy exception may still be established. Now, even if we were to entirely discount the effect of enforcement would have on HERA's public health, we say that enforcement would still be manifestly against HERA's public policy due to serious breaches of moral and ethical values. As provided for in the CJEU's decision of Renault and Mexico, public policy is to be understood as fundamental values, and this would involve both ethical and moral values. And turning to the facts of our present case, we say that GM had effectively treated the HERAN citizens as guinea pigs to test their vaccines. This can be seen on the facts, since first, the HERAN citizens had been induced into participating in the clinical trials with the promise that doing so would help save the lives of their elderly and their children. And this is stated in paragraph 5. However, in reality, the vaccine testing had the complete opposite effect, leading to the loss of many lives. Further, after the vaccine trials, GM had simply moved on to testing nitrosqualene and left the HERAN citizens to deal with the fallout of the trials on their own. Mr. President, Your Honors, I note that my time is up. If I may have 1 minute to sum up my arguments.
I would need one question for a minute, and I'm happy to grant that on the other side as well. You argued earlier that the claim and the counterclaim are largely unrelated. You're now talking, as I understand it, about the ethical concerns that are the conduct leading to harm to the HERA population due to the guinea pig situation, as you call it, which earlier you argued is unrelated here to the patent claim. Is that not a contradiction in your argument?
Respectfully, Mr. President, we would say that this is not a contradiction, given that the relevant requirement under Article 5.1L Roman numeral 1 is for there to be a logical chain of causation, and that such a requirement need not be established in order to invoke the ethical and moral considerations behind GM abusing the citizens of HERA. And if you're honest, and Mr. President oblige, I will quickly summarize my arguments. Now, after GM had conducted the failed clinical trials on the HERAN citizens, it is now even further taking active steps to seek to deny the HERAN citizens from addressing the widespread contaminations by seeking an injunction from this court to further its commercial interests. And we say that GM cannot be allowed to insist on the continued, or rather on the enforcement of the counterclaim at the continued expense of the health and well-being of the HERAN citizens, as this would constitute a manifest violation of HERA's public policy under Article 7.1c. Your Honors, Mr. President, I note my time, and unless I may be of any further assistance to this court.
Thank you very much, Counsel. Very much appreciated. We will now move to rebuttal by applicant 1 or 2.
Mr. President, I will be delivering the rebuttal for the claimants.
Thank you. Go ahead, Counsel.
Mr. President, Your Honors, the claimants have 2 points in rebuttal. First, on the claim, the defendant had earlier argued that the Brussels recast is premised on procedural efficiency and to avoid a risk of irreconcilable judgments. However, the defendants have neglected to mention that the fact that procedural efficiency must be balanced with an access to justice, as provided for in the definition of proper administration of justice referred to in recital 24. In any case, procedural efficiency can be achieved and a risk of irreconcilable judgments can be avoided by allocating proceedings from the forum that has the closest factual connection to the dispute, in this case, Belgium. Second, on the counterclaim, the defendants had earlier sought to rely on footnote 77 of the explanatory report to state that the main object of the counterclaim, or rather of the counterclaim, pertains to Ms. D's claim for damages. However, that is wrong in law because here in the counterclaim, GM has assumed the role of the plaintiff, and thus the main object of the counterclaim will be determined in accordance with GM's claim, which is for enforcement of a patent. This would squarely fall within the ambit of Article 2(1)(m). And unless I may be of any further assistance to this court, this concludes the case for the claimants.
Counsel, thank you very much. We will move to rebuttal by respondent 1 or 2, and I ask the timekeeper to add whatever the extra time is that claimants had in response to my additional question. I think that's probably 1 extra minute.
Thank you. Well, as the opposing counsel argued that it's in the purpose of the Brussels I regulation to gain this access of justice, we have to disagree. The purpose of the Brussels I recast is to avoid, in first instance, this irreconcilable judgments, which would result from not staying this proceeding between the Californian and this proceeding today. And as they furthermore agreed on the closest connection to the USA, there is no need to say that this hearing here today has a stronger connection and therefore a higher place in the hierarchical structure of the testings, excuse me, so that this proceeding here today must be performed onwards, but the Californian one. Hence, we urge the court to stay the proceedings furthermore. And as the opposing counsel suggested, that the proceeding contains not both the claim and the counterclaim, we have to disagree as well, as one must not isolate a counterclaim, but consider the entirety of the proceedings in their whole. So one must not isolate a single claim which would be in favor for his own party, but consider the entirety of the proceedings. With this, honorable bench, Mr. President, would like to conclude our submission and thank you for your attention.
Thank you very much, counsel. Thank you very much, counsels on both sides, for excellent pleadings. The court will now withdraw for consultation.
Yes, indeed. And the judges will now retire for deliberation. In the meanwhile, while we are eagerly awaiting their judgments, I have one practical announcement that I would like to make. As you all have probably seen, we have recorded these finals, and we should have warned you beforehand, but due to the delays and the hurries, we forgot to do so. But no worries, if any one of you would object to that, we will simply destroy the video. If there is no objection, then we will keep it and we will use it for documentation and information purposes. So now is the chance, if any of you would object to this recording being made, please tell us now. If not, we consider there is no objection from your side, and then we will keep it for later practical purposes. Okay, you all agree with that? Okay, thank you very much. Then we'll keep the video, and in the meanwhile, I would say just relax a little bit, and we hope to hear as soon as possible from the judges, and then we will start with the closing and awarding ceremony. I'll see you in a few minutes. Thank you very much.
Those who will tell us the definitive answers about who won this competition, I would like to first pass on the word to my colleague, a member of the Pax team, Professor Talia Kruger, because we thought that you would be also interested to find out a little bit more about, well, how the von Meeren round came into existence and what it was and entailed from the back end of the competition. So Talia, are you around? There you are.
Thank you very much. Thank you for this opportunity. So yeah, why the von Meeren round? Well, Arthur von Meeren was a great scholar of private international law in the US. And he was somebody who said, we really need a worldwide convention on the recognition and enforcement of judgments. And he also said that we shouldn't just copy the Brussels Convention, but we need a different approach. And he was also realistic enough to say, well, you know, we can't agree on everything. So let's make a list of grounds for jurisdiction on which we would all agree, and list a list that we would not agree on, and a sort of gray list. And he wrote a lot about this in his characteristically clear way. And I'm sure the students, when researching for this case, have come across his writings. Now, Arthur von Meeren died in 2006, which is exactly 15 years ago, which is why we thought this would be appropriate to commemorate him by dedicating the Pax round of this year to him. The judgments project that he worked on carried on a long while. Many of the people present here have also worked on the judgments project, the 2005 convention, subsequently the 2019 convention, which was also part of the facts of this case. So that's where it all kind of fits in. Many of the judges over the rounds, also in the preliminary rounds and also today, have personally known Arthur von Meeren or have studied with him. So we're very grateful that we can continue his legacy in this way. Now, about the facts of the case, in 2020, we were all struck by this pandemic. And I think it kind of slowly dawned on us that, you know, this is going to continue for quite some time. And the race to the vaccines, the way in which testing was done, and especially access to vaccines, were issues of really global problems and testimony to a world that is not as equal as it should be. This is what motivated the organizers to take this theme. And I'm sad to say that the recent events, what we've been reading in the press about India, is just again a sign of the inequality that is happening. And the fact that India is being criticized on one hand in the press in Europe for not doing enough, and on the other hand, India is wanting to suspend the patents of vaccines. So painful as it is, this was, I think, a relevant issue to tackle. The case was not written by one person. It was really a collaboration, and Daniel Tan, whom some of you might have met last year, took the initial steps, and then many of us contributed bits and pieces, and we took it from there. We should also acknowledge at this point Horace Mouirouat from Sciences Po in Paris and Hélène van Lith of Dauphine, who are really at the birth of the Pax Moot Code competition in general, right? They started off this competition a few years ago, small in Paris, and then growing. And we're happy to say that we are still growing even in this pandemic times. Behind this competition, a whole lot of people are working, an entire team. We have funding from the European Commission. We have a project which also entails judicial training. That, of course, has unfortunately been postponed due to you know what. But the other members of the Pax team, I would also like to acknowledge here today. Those are ESADA in Barcelona, Ljubljana, Maastricht University, Paris Dauphine, the University of Sofia, and the Asser Institute in the Netherlands. So thank you to all of you for being here. Thank you to the participants. Thank you to the judges, the timekeepers. Thank you to Laura of the University of Maastricht, who did a lot of work, as you have seen. Thank you.
Well, thank you very much, Talia, for mentioning that indeed behind the scenes there is more than one person or one team, and it's a team here composed of many institutions trying to collaborate in what we think is a nice way to bring together students and hopefully one day again on campus. Look, the next person who was willing to say a few words on behalf of the European Commission, who is actually our sponsor and has been believing in this project for a couple of years now, is the deputy head of unit in the civil justice unit, I guess, in DG Justice and Consumers of the European Commission. I might have gotten the title wrong, forgive me for that. Pia Lindholm, and she is unfortunately able to join us. She has experienced the same technical problems that some of you may have experienced also at the outset. And as we have a colleague of hers in the person of Judge van der Kerkhoven, Karen van der Kerkhoven, official and head of unit, gender neutrality, in the same DG. Can I ask her perhaps to say a few words, this time on behalf of the European Commission?
Yes, thank you, Marta, and I'll just take another hat for a few minutes. So thanks to all the organizers for this moot court. It's a fantastic experience, I hope, for all of you, particularly for the students. I must say, well, I was able to attend today's session, so I'm really impressed. We'll come to it in a few minutes, but just also to say that the reason why we support this project indeed and this moot court is because we see the importance of private international law and the importance it has and it should have, we think, for students to learn it from the beginning of their career. If you can see how private international law has contributed to the judicial integration in Europe, how it has brought legal systems together, then I think we hope that it can inspire also the rest of the world through the Hague Conference, through all of you who study private international law abroad, and I must say I'm really impressed to see how students from all over the world cite European Court of Justice cases as if it were their own. And I think that's great, because it in this way, this is exactly what the such a moot court can achieve. Yeah, is that the knowledge of each other's legal systems, the spreading, seeing how courts in other jurisdictions deal with matters, because it's not only courts, ECJ case law that I have heard cited here. I've heard cite cases from all over the world. And that's exactly what I think are the challenges ahead of all of you, all of the students who will be global players in a small world, which I think we have seen even more since last year, yeah, how small the world is and how we are affected by all the challenges and the problems of today. So thanks Marta, thanks Talia, thanks to all those who are behind there somewhere who have organized this for this excellent organization, and thanks to the students for participating, even if you didn't make it to the finals, even if you didn't make it in the finals. I hope you had a great learning experience and got to know people also from all over the world.
Oh, thank you so much, Karen, for these very inspiring words for all of us in the private international law community. Without really no more delays, we go to the awards ceremony. And I think, yes, you do remember, don't you, that a long time ago you did complete with a lot of effort, I'm sure, some written submissions. And you may have wondered since then, you know, who did evaluate those. So we can disclose a little bit of that. There is a team of evaluators who did a wonderful job in reading and grading those written submissions that you submitted in March, was it? And then can I invite one of our evaluators, and that is also a colleague who some of you may have encountered as a judge, Chukuma Okoli. So Dr. Okoli, I have seen you already. There you are. Nice to see you back. And well, again, together with your colleague, Vesna Lasic from our Pax partner, the Asser Institute, you were going to tell us who are the winners or the runners-up and eventually the winner of the best written submission. So please go ahead.
Yeah, thank you very much, Marta. Vesna should have joined me, but she couldn't join me due to technical difficulties. So it's been very interesting reading the written submissions by the students in the Pax Moot and being one of the judges in the Pax Moot competition. That's been very thrilling and exciting. So without wasting much time, I'll mention those who the first three teams for the claimants and the first three teams for the respondents. Then I'll mention the overall winner for the written submissions. So there were three teams that came out jointly taught for the claimants. Three teams: Erasmus University Rotterdam, ESDAD Law School, and Ghent University. So these three teams came out jointly taught for the claimants. Then at second position for the claimants written memorandum is Università degli Studi di Milano. Sorry, excuse my Spanish. So this thing came out second for the claimants written submission. In first position for the claimants written submission is Università Cattolica di Sacro Cuore, Milan. So this thing came out first for the claimants written submission. For the respondents written submission, in third position is Università Cattolica di Sacro Cuore. And the second position for the respondent written submission is Ghent University. In first position for the respondent written submission is Singapore Management University. Overall, for the best written memorandum in the written submission, please don't hold your breath, is Università Cattolica di Sacro Cuore of Milan. So congratulations to this team. Thank you very much.
Well, thank you so much, Okuma. Yes, I wish this university would be in Spain, where I come from. But it's an Italian university, and I don't know if one of the members of the Sacro Cuore University are with us. Are you?
Yes.
Okay, so
if I may, I would like to thank you all, because it was an incredible experience and we learned a lot, and it was amazing to discuss about law with other colleagues from all around Europe and all around the world. And we would like to thank you for this great experience that will guide us for the rest of our life. Thank you very much.
Thank you very much.
Yeah, thank you.
Thank you very much. And with that, I would like to give the floor to really the beating heart of this competition, who has been working day and night over the past weeks and especially the last days. And this is our student at Maastricht University and the executive secretary of this competition, Laura Sarney. Where are you? There you are, Laura.
Yes, thank you, Martha. So welcome everyone. First of all, I would like to congratulate all of the participants on your very, very hard work and your preparation for the competition. I think we have seen some excellent, very high level pleadings throughout the entire competition and also here in the finals today. So I am very glad to be announcing the Best Pleader Award. So this award goes to the pleader, either the applicant or respondent, who has achieved the highest average individual score in the general round. And so without further ado, this year, this award goes to one of the pleaders from the semi-finalist teams, the University of Oxford. And the student who gets this award is the pleader by the name of Mr. Alvin Chung. So I'm not sure if he is present, but congratulations to him and his entire team. He has achieved some outstanding scores throughout the general rounds, and he had a fantastic overall performance. So congratulations. Thank you.
So can I check? Thank you very much, Laura, for a very beautiful announcement. Can I check whether Mr. Chang is with us? Is there a colleague of his from Oxford? Doesn't seem to be the case. Okay, but never mind. Very well done. And well, this makes it all the most exciting to see that actually the best pleader didn't make it to the final, but that brings us to where we are now in the finals. And for that, I give very gladly the floor to the presiding judge of our Pax bench, Ralph Michaels.
Thank you very much, Martha. Thank you, Laura, for all the organization and everyone else. This is really an exciting thing as a now aging private international lawyer, to see the excitement and the quality of young private international law students that they bring to a moot court like this. It is a great pleasure, a great honor at the same time, I think, for all us judges to be here and to be able to preside as judges over a moot court like this, and indeed to see such excellent performances as we did, I guess, all over. I tuned in some earlier rounds, but certainly also in the final. So congratulations, not just to the two finalists, but really congratulations and thank you to everyone who participated. Now, the three of us had to judge the final, and of course, judging a final is always difficult. It's in part difficult because teams come from somewhat different backgrounds. We had, on the one hand, we had one team where I understand at their university, my recollection is classes are in English, whereas for the other participant, classes are typically not in English. On the other hand, of course, we had a set of applicable laws that included laws that may be more familiar to students studying in Europe, in Cologne in this case, than they would be in Singapore. And then thirdly, of course, we have one team from a civil law jurisdiction and one team from a common law jurisdiction. And it was interesting to me to see that the different characters, if you want, were matched also amongst us amongst us judges. We have one judge predominantly from a civil law jurisdiction, that is Karen. We have one predominantly from a common law jurisdiction, that's Louise. And we have myself, who spent so much time in both the United States and in Europe that I'm really neither here nor there for that. And of course, fourthly, what makes it difficult to judge, of course, in all of such facts is that the role of applicant and respondent sometimes are easier or harder depending on which case is harder to make. So I would think that the applicable law case was very hard to make in favor of Belgium, and the counterclaim case was very hard to be made in favor of inclusion of the counterclaim in the recognition. And both teams had one of those, and both did that actually admirably. So congratulations first on that. Congratulations for both teams for their knowledge of the law and for their knowledge of the facts. Of course, you would not have made it to the final had you not been really good at that. We felt both teams were excellent, both teams deserved to win, but we nonetheless felt that in the end, the edge belonged to the team that seemed to us to be slightly above in their performance in the litigation. And the team that was very structured in their presentations and yet at the same time very flexible in responding both to our questions, and some of our questions were really meant to put you out of your habit. They were questions from left field, as you say, to confuse you. And that team was really impressive in how they would not let us confuse them. They were also impressive in how they would respond to the arguments that the other side had brought and put those into their arguments. That team also, we thought, had a slight edge in their seemingly effortless use of a broad array of sources, both as concerns the report and as concerns judicial decisions, even not in their presentations, but in responding where that suddenly became necessary. So in that sense, it's for those reasons that we feel, although both teams were very good, the winner of the 2021 Van Meeren round of the Pax Moot Court is Singapore Management University. Congratulations to both, but special congratulations to Singapore Management University.
Well, what a fantastic end of this 2021 round. Well, maybe our winning team would like to say something at this stage. I see them together as we have seen them throughout the competition. Yes, please, Grace.
Everyone, thank you so much for this opportunity to participate in a moot based on private international law. And it was really such an honor, and we really enjoyed our time. Thank you to all the judges, and we have really benefited from your experience, as well as to the other competing teams who have been great sports. Oh, and in particular, we just want to thank our finalists, participants, the University of Cologne, for a really good argument and experience as well.
Would the team from Cologne also like to add a few words?
Thank you very much. First of all, congratulations to our very strong opponents from Singapore. Deserved win, even though the final was on such a high level that we ourselves were surprised by our performance. So, and then, of course, our thanks extends to everyone who was involved in organizing this moot court, which was a really great experience for every one of us. Thank you.
Thank you so much for these kind words. With that, we come to the end of what has been quite a busy week, hasn't it? And for that, I would like to give the final floor, the final word to my colleague, Stefan Rutte. Stefan?
Thank you, Marta. With me taking the floor, we've reached really the end of this moot court. The end of a moot court always makes me wonder what will happen to the parties. Will Ms. Lee goes into politics and will she become the first female president of HIRA, or will she fall in love with one of the young attorneys representing her in front of the Belgian or American courts and live happily ever after? What will Global Medical do? How will they at a certain point settle with the victims of the clinical trials? Will they become the first pharmaceutical company to share their patent so that HIRA can start producing vaccines for its own population? Unfortunately, we will never know, and it's up to your own imagination. A modern concept of legal education is to learn by bringing about proportionate admixture of reading, observation, participation, and practice. No one can learn swimming merely by reading a book on swimming. He has to get out in the water, learn how to float and start practicing, and finally manage to swim. Though the subject of law is the human being, the law education has for a long time dealt with it in a two-dimensional projection of the subject, like a print on the page. The modern legal education proposes to accept its subject in its three-dimensional form, with flesh and blood and with emotions and a lot of difficulties. Law teaching and learning is not purely doctrinal. Clinical experiences, extracurricular activities, and skill courses have to be a part of the learning process. Law students must learn the substantive law, the procedural law, private international law, and also lawyer skills. An ideal course of studying in law is a combination of theory and practice, substance and processes, knowledge and technique. Of necessity, the legal education has to intermingle moral and ethical issues with legal issues so as to answer the needs of a vibrant society. As the case of this year illustrates, moot courts are the perfect tool to achieve this. Moots strive for inculcating in the future lawyers the art of being articulate, developing fluency and clear enunciation of thought, learning the art of persuasion, and making a succinct and intelligible putting up of a case. After attending some of your pleadings and after attending the semifinals and the finals, I'm convinced that we've checked all those boxes and that it have been 3 wonderful days. We hope you also enjoyed the past 3 days and that you all will become ambassadors of this moot court, encouraging your coaches and other students to participate in future editions. As our Vice Dean already indicated, no one can predict what the future will bring. However, there's one certainty. There will be a 2022 edition of the Pax Moot, in real life, if possible, and otherwise once more online. As colleague Taya Kruger already indicated, we have to be grateful to all our partners, especially the European Commission, for its support. We are also very grateful to all our academic partners, which were present in this moot court as judges and also motivated their students of their respective institutions to participate in this competition. They helped us with evaluating the written memoranda, preparing model answers that we were able to distribute amongst all the other judges. And of course, as Marta already indicated, the beating heart of this competition was this year Laura. So many thanks to her. I think we also should mention Philip, who was the webmaster of our website, on which you, by the way, also can read about the other side of the Pax project. And of course, there's Daniel Chang, which also was already mentioned by Talia, who was our former executive secretary and who passed all his experience and knowledge to Laura and Philip. To conclude, all of us, and then I think I can also speak on behalf of all the organizers and all the judges, all of us are very proud of you, and we wish each and every one of you a bright and colorful future ahead.
And this concludes the ceremony and the round, as said. And so we can only wish you at this stage a very good weekend. And if we haven't done this before, and apologies if we have, I would like also to thank the EDRC for connecting us all together and making this online competition possible. It has been a pleasure to work with you. Bye-bye.
Thank you very much, Marta. Just to thank you from the IDRC, and congratulations to everyone who participated. Thank you very much.